Welcome everyone. Thank you for joining us in what is the final webinar in a series of Brexit webinars that have been taking place all week. The recordings for all 5 webinars will be available on the Burness Paull website shortly. First up today is my colleague Joanna Fulton, who leads our product liability team, and will be speaking about how product safety and standards are affected by the end of the transition period. She's followed by another one of my colleagues, Lynn Moss, who is an expert in health and safety law, and she will be speaking about the effect of the end of the transition period on health and safety and environmental rules. She'll be followed by me, and I'm going to be speaking about the effects of Brexit on procurement and state aid rules. But before Joanna starts, just want to mention these housekeeping points. Please ensure your mute button has been selected to limit any background noise. We've automatically muted you when you join the call, but if you could just make sure you keep yourself on mute, that would be great. If you have any questions, our contact details will be available at the end of the session for you to get in touch with us, or enter your question in the chat function, and we'll extract those at the end of the session and get back to you. We are recording today's session, and this will be made available to everyone afterwards. So thank you everyone for joining us, and I'll hand over to my colleague Joanna Fulton. Thanks, Joanna.
Thanks, Graham. So I'm going to be talking about product safety rules that are changing post-Brexit. There's a gamut of product safety rules at EU and UK level, and in general these seek to ensure that firstly products are safe, and secondly where issues do arise with the product that these can be identified and contained as quickly and effectively as possible. And the system relies on recognition and harmonisation of rules and standards across the EU, creating a single marketplace for goods. After Brexit, the UK is no longer going to form part of the single market, and assuming a no-deal Brexit, the UK will be free to depart from EU standards, and as such, there can no longer be a presumption of conformity or harmonisation of standards. In turn, the UK will no longer form part of the current EU product safety regime. So UK-specific regulations around product standards and traceability of products are being developed to deal with this. And in turn, the EU is developing its own rules for goods coming from the UK. And I'm going to take a quick gallop through some of those rules now. So there's 5 points that I wanted to make to you. The first point is that for products being exported from Great Britain into the EU, changes will be required immediately on Brexit, i.e. on the 1st of January 2021. In other words, if you're exporting into the EU, you need to make changes right now and fast. For manufactured goods that are already on the market in the EU, no changes are needed. But from the 1st of January 2021, if you're exporting products that are CE marked, and you'll have seen the CE logo on many products that you buy, and the goods have gone through a conformity assessment by a notified body based in Great Britain, you may need to have your products reassessed by an EU-based body or a certificate transferred to them. Again, from the 1st of January 2021, EU-based entities who are importing the goods into the EU from Great Britain and placing the goods onto the market in the EU will constitute importers, and their address details must appear on the goods or packaging. And I'm going to talk about importers a little bit more in a moment. The second point I wanted to make is that for products going the other way, i.e. from the EU into Great Britain, a grace period has been built in by the UK government to allow a longer time to comply with the changes. In other words, if you're importing goods into Great Britain, you have some time, although there are some exceptions to that. If manufactured goods are already ready to place on the Great Britain market as at 1st of January 2021, then no changes are required. Instead of the European Union CE marking, there's going to be a new UKCA or UK Conformity Assessed mark. For goods that are CE marked, these will eventually need to be replaced by the new UKCA mark. There's a grace period until the 1st of January 2022 to change over to the new UKCA mark. And it's also, though, the same position applies in relation to those bringing in goods into the UK. A distributor based in the UK bringing in products from the EU will be classed as an importer, and their name and contact details will need to appear on the product or packaging. However, unlike with goods going the other way, until the 31st of December 2022, those details can be on documents accompanying the product rather than on the product or its packaging itself. A third point I wanted to mention is that companies who were previously only acting as distributors will now be classed as importers if they are the first people to place products on the market. So distributors who are bringing product into their territory from the EU into Great Britain or vice versa and placing it on the market there will be classed as an importer. That's a change. This brings it with significantly increased obligations in relation to product safety. Essentially, an importer will have much the same responsibilities as a producer in terms of product safety, compliance with relevant rules and standards, presence of relevant documents and labelling and so on. This includes having the name and address of the importer on the product or its packaging. Similar obligations will also fall on the representative of a manufacturer based in the territory. So companies who were previously acting as distributors but who will now be classed as importers may not be willing to fulfill this new role or may require compensation to take on this new role. The other options might be for a producer to have an operating facility in the relevant territory or to ask a customer to take on this role. The second option seems perhaps unlikely. The first option comes at cost, but it's something that we know many companies have been looking into. The penultimate point I wanted to make is that there are specific rules covering food products. And for food, the EU GB distinction in terms of the timeline differs in similar fashion to the goods that I mentioned, to general products that I mentioned before. So for food placed on either market before the 1st of January 2021, this can continue to circulate without any changes. For GB exporters into the EU, prepackaged food must have an EU address of the food business operator or importer on the packaging or labelling from the 1st of January 2021. Labels could have both an EU and a UK address, and it might also be possible, at least as a temporary measure, to affix an over sticker onto the existing label in order to achieve this. Exports to the EU cannot carry the EU Organics logo, the EU emblem, or the Origin EU label. However, for imports into Great Britain, prepackaged food can continue to use an EU address until 30th September 2022, and also producers can label food as Origin EU until the same date. There's specific guidance for food types like meat, fruit and veg, olive oil, honey and eggs, but this is not really something for today. The last point I wanted to mention, which really is illustrated by the rather convoluted distinction I've been making in terms of mentioning GB rather than UK, is that goods going into Northern Ireland have to comply with EU rules. Under the Northern Ireland Protocol, Northern Ireland will remain part of the EU single market for goods, and this means the EU rules will apply to goods going into Northern Ireland. So as I said, that explains the reason for saying Great Britain rather than UK in what I've said before. So this brings with it various headaches, such as in relation to labelling a product sold on the Northern Ireland market. There's also going to be a new UK NI mark that must be applied in certain situations alongside the CE mark for products sold in Northern Ireland. And the new UK CA mark cannot be applied to goods sold in Northern Ireland. So companies bringing goods into Northern Ireland from Great Britain and placing them on the market in Northern Ireland will be an importer into Northern Ireland, with all the consequences I mentioned earlier. They'll have to ensure that goods comply with relevant EU rules and standards. Similarly, food sold in Northern Ireland will still need to follow EU rules for certification and labelling. Where country of origin must be stated on food under EU law, these labels will need to say UK brackets NI brackets from the 1st of January 2021. And on labelling, the name of the food business operator or importer will need to be based in Northern Ireland or the EU from the 1st of January. And you may have seen the press as various supermarkets and others have been warning that certain food lines may not be available in Northern Ireland given the difficulties of complying and the timescale for doing so. And negotiations have apparently intensified over recent weeks to try and create some flexibility to relax these requirements. So in conclusion, there are some complex changes in terms of regulation and labelling that are going to take place for products. For exporters into the EU, action is needed now to prepare for these changes from the 1st of January. For importers into Great Britain, there will in many instances be more time to get ready. The prospect of a deal that covers these issues and allows products to circulate freely seems unlikely in the short term, and producers and others in the supply chain no doubt will be hoping that a deal might be struck, though, to alleviate some of this red tape in the months to come. Thanks. I'm now going to pass over to my colleague Lynn Moss, who is going to cover the health and safety angle. Thank you.
Thanks, Joanna. So if we cast our minds back to 2016 and the months and years of negotiations and speculation that followed, there was a feeling that health and safety law in the UK would be diluted to a certain extent and become less strict, for want of a better word, when we left the EU. Thankfully, that seems to have turned out to be a bit of a myth. And what is clear, at least in the short term, is that there will be a limited impact in terms of UK stakeholders' obligations to comply with health and safety law. Whether that will always be the case is, however, unclear. That said, the clear message from government and the Health and Safety Executive at the moment is that your legal duties to ensure the safety of your employees and others affected by your undertaking will not change after Brexit. The Health and Safety at Work Act 1974 underpins the UK's health and safety regime. It's been in force for over 45 years and for the large part has stood the test of time. Various EU regulations have supplemented the 1974 Act over the years, but together the UK and the EU are seen as having a robust health and safety regime, and in terms of the UK that will not change on 31st December. The Withdrawal Act has made sure that all health and safety regulations and directives derived from EU law are incorporated into UK law and will continue to apply to UK employers after the transition period ends. That said, the regime that specifically regulates the chemicals industry will see some immediate changes, such as changes relating to biocidal products, chemicals classification, labelling and packaging, export and import of hazardous chemicals, pesticides regulation, and the regime relating to REACH, which is the authorisation and registration of chemicals. For each of these, the UK will develop its own regime that will operate independently of the EU regime. The UK Health and Safety Executive will become the authorisation body for chemicals that are to be used in the UK in place of the European Chemicals Agency. And imports and exports of listed chemicals will need to comply with the new UK regime, which, as far as I can tell, seeks to mirror the current EU one. One area where your role might change significantly is in relation to REACH, where there will be a new UK REACH regime which will operate independently of the current EU REACH regime. UK businesses currently holding an EU REACH registration or authorisation will be able to have that recognised in the new UK system, but you'll need to make sure that you've opened an account and provided required information to be able to access the new system and place chemicals on the UK market. For access to the EU market, you will need to either transfer your registration to an EU or EEA-based entity, or have your EU or EEA importers become registrants. EU companies wishing to import chemicals into the UK will need to be registered with the new UK REACH system. New rules may also apply if you import chemicals from an EU-based supplier or you are importing or exporting to or from Northern Ireland, which will continue to use the EU regime. Other changes, as Joanna mentioned, relate to the phasing out of CE marking of goods and equipment. And from 1st of January 2021, the new UK Conformity Assess system is the marking to be used for goods to be placed on the UK market. To allow businesses to adjust, the EU CE marking can be used until 1st of January 2022 in most cases, as Joanna also mentioned. This will be relevant from a health and safety point of view, not only for all UK-based manufacturers, but also those employers who have a duty to provide work equipment, which is safe. There has been a suggestion that a no-deal scenario could mean that the UK will look to deregulate or dilute its health and safety laws to become a more attractive trading partner. Whether that's true or not, where we might see issues arising further down the line is if the UK and the EU regimes do diverge for whatever reason. I can see that having an effect on businesses that trade in both the UK and the EU, as they will inevitably need to get to grips with both regimes and ensure compliance with both. For example, enhanced training might be required for workers that are not from the UK if the UK regime starts to become vastly different to the EU one. One thing is for certain, a commitment to managing workplace risks and ensuring the safety of employees and others will remain a priority for the UK regime going forward. And continuing to make health and safety a priority and ensuring that you know how any changes affect you will go a long way to helping you comply with your duties. In relation to environmental standards, in the short term, the position in relation to environmental law in the UK will be very similar to health and safety law. The UK and devolved governments have committed to ensuring that existing EU environmental law will continue to operate in the UK along with environmental targets and the current enforcement and permitting regime. After 31st of December, however, any new EU environmental laws will not automatically apply to the UK, and it will be up to the UK government to decide whether to incorporate them into UK law. The main impact on environmental standards in the UK in the short term will be the governance gap that's created by the EU no longer having oversight of the UK's environmental policies and regulatory regime. Whilst the EU has taken the UK to court relatively rarely over the years, there is no doubt that the threat of court action has acted as a deterrent for the UK. This has led to concerns that the UK could take a huge step backwards in terms of reducing its environmental impact and its policy on climate change generally. The UK intends to create a new governing body to replace the EU Commission called the Office for Environmental Protection, and a bill is going through the Scottish Parliament to introduce a body called Environmental Standards Scotland. Neither of these bills have been passed as law yet, and if the bills are not passed on time, then the UK and Scottish governments have said that interim measures will be put in place, but it's not clear what those will be yet. In summary, there will not be too many changes felt in these areas in the immediate future, but what the future holds is uncertain, as with many areas. Meantime, if you deal with chemicals or other hazardous substances, make sure you are complying with the correct regime and you have the appropriate authorisations and registrations in place now to avoid any delays come 1st of January. And that's all I have to say on those areas. I will now pass over to Graham, who'll talk about procurement and state aid rules.
Thank you both, Joanna and Lynn, for your great talks. So I'm going to talk about the impact of Brexit, or more accurately, the end of the transition period on public procurement and state aid. Firstly, procurement. You'll be pleased to hear, or possibly not, depending on your perspective, that the UK government is intending to take its time to introduce new procurement legislation. As at the 1st of January, the current rules will only be subject to minor changes, such as deletion of references to the European Commission and changes from the official journal of the EU or OJEU to Find the Tender, which is the UK's new procurement portal to replace OJEU. And this is a pan-UK portal. From a practical perspective, if you're operating in Scotland, you'll still use your Public Contracts Scotland portal, and it will automatically push your notice through to the new equivalent, the new replacement for OJEU, the Find a Tender portal. There are, however, likely to be changes forthcoming at some point next year. Earlier this year, turn of last year, I attended a meeting when we were allowed to actually have physical meetings with people, a consultation meeting with Cabinet Office representatives who are currently involved in the drafting of the new procurement legislation. While at that time the legislation had not been finalised, it was obviously going through that consultation process, and obviously it could still be subject to ministerial intervention. It was reasonably clear the path and the process that they were following. They were looking to put in place a more streamlined version, something similar to what we have at the moment. And it was clear that they intended to continue with the absolute requirement for a regulated procurement process. It certainly wasn't going to be a fee-for-all. I think they recognised that it did bring good value to government, that there were a number of procedures, including my favourite, the Innovation Partnership procedure, which they were intending to continue with, and that there would be a civil enforcement procedure. So whether that was through the courts, and they did say that they were giving consideration to a tribunal process, but again, that may come at a later time as well. So it did look as though there would be a streamlined version, hopefully simplified version, but nonetheless something which those of us who are involved with procurement, would be reasonably familiar with. However, again, must emphasise none of that was finalised. It was almost a year ago, and obviously, as I said, we have seen things seem quite certain, and obviously there's a huge amount of uncertainty. But it does seem, as I said, that nothing is really going to be changing as at the 1st of January. So one question that's been asked of me is that if we have the discretion to start a procurement process before or after the 31st of December, which one would we do? So without knowing what the free trade deal, if there is going to be one or not, is going to say, and whether it will actually include new conditions in relation to procurement, we don't yet know. But on the basis of the information that we have at the moment, my view would be that we wait effectively until after the end of the transition period. And the reason for that is that any procurements that are started before the end of the transition period are still going to be subject to the EU rules, and effectively still, after a continuing period of a couple of years, still have that Commission oversight and ultimately the Court of Justice of the EU oversight. So it seems to be a kind of very small advantage that if you have the option to wait until the end of the transition period, and again subject to any changes that come through the free trade agreement, but actually just waiting until then will effectively mean that you will not be subject to the EU Commission regulation nor the oversight of the Court of Justice. You will, as I said, still be subject to the jurisdiction of the UK courts. And again, for that basis, it would seem to me that waiting would be a little more advantageous. Turning now to state aid, this is actually much more difficult, given it's one of the three areas that have been identified as causing a lot of friction, shall we say, in the free trade negotiations. And that's not even the one I was discussing with Joanna about the ability to export chilled sausages and burgers into or out of the EU without them being frozen to -18, reminding me of that great episode of Yes Minister, Yes Prime Minister and the Euro sausage. But nonetheless, as I said, I'm sure that will come in further detail. So here's what we know at the moment. There is draft legislation, the naturally named the State Aid Revocations and Amendments EU Exit Regulations 220 2020, which you ultimately are in a draft at the moment, and if brought into force, will revoke the state aid rules in their entirety at 11 p.m. on the 31st of December. So effectively, the treaty provisions, the general block exemption regulations, and any other provisions which currently allow UK authorities to provide state aid will effectively be swept away in one swoop. At the moment, on the basis of this legislation, if it were brought into force, would mean that there would be no state aid rules in the UK at that time beyond effectively the World Trade Organization subsidy control rules. And for those of you who are unfamiliar with those, they operate at a higher level. You may have heard in the press recently that the EU has been permitted to grant create sanctions, basically charging more taxes, more subsidies for the subsidies that were given to Airbus and Boeing, and the US has been given an equivalent right to make sanctions against the EU because of those subsidies given to those airlines. So again, it tends to operate on that basis as well. If a trade deal is entered into with the EU, it will be something much closer to a middle ground. What has been identified through the free trade, what we've picked up from the press, is that any state aid or subsidy control rules will follow the same state aid principles as the EU rules. It will not be the EU rules. It will not be subject to the Court of Justice. It will not be subject to the determination of the European Commission. So effectively, there will be rules and principles that are set by the UK, but they may be similar and may be familiar to the principles that underpin the EU state aid rules. It's also clear from negotiations that there is a requirement, certainly from the EU's perspective, and I think a recognition that there has to be some form of enforcement mechanism, and it seems to be that that will either be a UK regulator or, and again, whether that is the Competition and Markets Authority or whether another body that would be responsible for state aid, again, but it does seem to be that there will actually be some enforcement mechanism within the UK that would allow individual companies who feel aggrieved that a competitor has received unlawful subsidies who could make that enforcement mechanism. If there is no trade deal entered into the EU, it does seem to be still that the UK government does intend to legislate in state aid, despite their comments to say that they may not and may just rely on WTO rules. First of all, under the draft Internal Markets Bill, state aid legislation has been stated to be a reserved matter, which means that the UK government has retained, and the Westminster Parliament has retained the right to legislate on state aid. There's a statement in there basically stating that Scottish Parliament, Scottish government cannot grant aid which will distort the internal market once that's created by the Internal Markets Act. The government has also expressed concern around subsidy wars between the nations and the regions, and again, that's something that they want to avoid. It seems to me that relying purely on the WTO cannot achieve that goal and aim. Effectively, there has to be something else, another layer of legislation, another degree of enforcement within the UK to avoid that from happening. So I'm going to ask the same question again that I asked about procurement. If you have the option to grant state aid, before or after 11 p.m. on the 31st of December, which option do you choose? And again, this one is going to be slightly less clear cut, and it also depends on what's likely to happen with a free trade deal, which will become clearer as time goes on. So firstly, if you have a scheme, whether it's under the general block exemption scheme and or it's de minimis, and it's clear that you can provide funding under that scheme, there's no questions about it, no debate about it, then it seems to me that the better option is to go with the certainty that we have at the moment and make use of that scheme and provide the funding under that particular scheme, and make that commitment there. If you are less certain and or there's a question mark about whether something would fit within a scheme or whether something is and it's not state aid, then it seems to me that actually what might be more advantageous is to leave it till after. We don't know what's going to be the position as at 11 p.m. on the 31st of December, but it seems to be that at the moment there's a possibility of some greater flexibility, but as we say, that will become clearer as we approach the end of the transition period and negotiations progress to their conclusion. So just to conclude, there is a huge amount of uncertainty when it comes to state aid. Procurement, as I said, is much clearer. As I said, the legislation is going to be largely the same at the end of the transition period, with changes coming in at a more leisurely pace. State aid, as I said, it's watch this space, watch the news, because it's clearly one of the key topics. Okay, that's me. Thank you, everyone, for your time. As I said, this webinar has been recorded, and you'll receive that recording early next week. Please do get in touch if you have any questions, and thank you very much for joining us.